I begin today by acknowledging the traditional custodians of the land on which I present today and pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples that may see this presentation. Despite a Royal Commission over 30 years ago into First Nations deaths in custody, First Nations over-incarceration and deaths in custody remain a significant issue. This is a reflection of the disadvantage First Nation Australians continue to suffer in modern Australian society. Because of this, First Nation status should be factored into sentencing decisions. Currently, this does not occur. The case of Bugmy v the Queen has set the current law in Australia in respect of this issue. It followed the Fernando principles, meaning that a background of social deprivation broadly is a relevant factor in the determination of an appropriate sentence, but an offender's First Nation status of itself is not relevant to sentencing. The practical effect of following these principles is that sentencing judges take into account the background of a First Nations offender in a way that is no different from how they would take into account the background of any other offender. This was a mistake, as First Nation status should, of itself, be a determining factor in sentencing, rather than only indirectly through social deprivation. On a general level, First Nations status needs to be accounted for because of the unique systemic experiences First Nations Australians have. The basis for First Nations Australians' historical trauma is well documented and spans multiple generations, as despite colonisation occurring in the past, its effects and legacy are ongoing, because it is not just an event, but also a structure. This historical and individual trauma, alongside continuing socio-economic disadvantages, contribute to First Nations Australians being arguably the most overly imprisoned population in the world. First Nations women are in particular need of their circumstances being accounted for in sentencing, as they are being imprisoned at a rate that is growing faster than First Nations men. In fact, they are the fastest growing prison population in the country. A significant driver of this is being a victim of violence, particularly family violence, as these experiences dramatically increases the likelihood of First Nations women becoming offenders. Because of this, and other victimizing factors, First Nations women have a very different experience of social disadvantage to First Nations men. However, by following the Fernando principles, which overly centralize the male experience of social disadvantage, the Bugmy decision marginalizes the female experience of offending, and subsequently the effect of factors such as family violence on offending. An argument that is usually given for First Nations background not being directly relevant to sentencing is that it clashes with core Australian sentencing considerations. Individualised justice is one such consideration, as it is foundational to sentencing in Australia, and it occurs through tailoring the sentencing process to the particular offender and particular facts of the case in a way that treats everyone as equal before the law. There is the concern that by considering First Nation status by itself, this breaches this point of equality before the law, as it necessitates treating First Nations Australians differently than other Australians. In fact, the High Court's position in Bugmy reflected this concern. However, I would argue that this is a very limited and overly literal application of individualised justice. Individualised justice in sentencing requires proportionality not only to the harm, but to the circumstances of the offender. It also applies the principle of equal justice, not just by providing that people should be treated alike, but also by providing that allowances should be made for relevant differences. This recognises a more nuanced and important view of equality before the law, by recognising that individualised justice contributes to substantive equality, not just formal equality. The other sentencing considerations this change would appear to clash with are community protection and deterrence. Punishing offenders through a loss of liberty is traditionally thought of as protecting the community and deterring the offender, and therefore being more lenient on First Nations offenders counteracts this. However, the current view of deterrence and community protection overestimates imprisonment's ability to reduce crime, and therefore misses other strategies that may be more effective. The ever-rising imprisonment rate demonstrates that longer prison sentences for First Nations offenders are not having the desired effect of these principles. Ultimately, contrary to traditional views, consideration of First Nations status can actually facilitate deterrence and community protection in the long run by aiding in reducing recidivism and not further perpetuating disadvantage. Support for these changes also comes by looking at other jurisdictions. Specifically, Canada is a good example of a jurisdiction that has, through legislation and court decisions, held that sentencing judges must recognise systemic factors unique to First Nations Canadians. Unlike Australia, Canada recognised that sentencing mechanisms that treat First Nations and other individuals the same might appear to uphold equality, but actually fail to provide substantive equality to First Nations offenders. The Canadian approach to sentencing also promotes restorative sentences for First Nations offenders that prioritise rehabilitation and community healing. Given that First Nations Canadians operate in a similar socio-political context to First Nations Australians, there is no reason why the law in Australia cannot follow Canada's lead. With all this in mind, the law has to change to consider First Nation status in sentencing. This status of itself needs to be a mandatory factor in sentencing, rather than considered indirectly through social deprivation in the same way as other offenders. Given that higher courts have been reluctant to create this principle when given the opportunity, like in Bugme, this should come through legislation. We should also follow Canada's lead and promote restorative sentencing programs that pursue rehabilitation and healing. There is strength in a shared history of survival and continuing connection to First Nations land, cultural relationships, and laws, and this strength offers potential for rehabilitation and healing in a collective context. Therefore, it would be ignorant and wasteful not to take advantage of this potential. While these changes by themselves will not solve the litany of issues First Nations Australians face, they are a necessary step in fighting them. Thank you.